What if my I-751 gets denied? Hi, I'm Jim Hacking, immigration lawyer practicing law throughout the United States out of our offices in St. Louis, San Diego, and Washington, D.C. I was at my daughter's softball game yesterday, and I saw something that I hardly ever see. An I-751 denial. I was in shock. Now, one thing that's funny about immigrants is they don't always send me good scans. So this was pictures of a 751 denial on somebody's kitchen table. And so when I started making my way through it, I thought, how could this 751 get denied? And I also thought the name on the I-751 denial was a name that I knew. Now, this was someone who we did an I-130 petition for. We got this person their conditional green card. They went ahead and filed their I-751 without us. Now, that happens from time to time. No hard feelings. I know people think that they can do things themselves. I do think that's the biggest mistake people make when it comes to immigration. It's not so much which attorney that you hire, it's these people that think they can do it themselves. And this denial is proof positive of what I'm talking about. Now, this is a case that never, ever, ever should have been denied. And I really, really mean it. I can't think of another time that I've seen an I-751 denial. Now, let's do a little background and talk about the I-751 process so that we're all on the same page, and then I'll tell you what's happening now. All right, so here we go. This person was from out of the country. They came to the United States. They married a U.S. citizen, and they applied for an immigration benefit, namely a green card, based on their marriage to a U.S. citizen. And like I told you, we filed all the evidence in support of that application, and we got that case approved. Now, like so many other people, this green card got approved before the marriage was 2 years old. And what that means is that USCIS will say, you're a lawful permanent resident, but that residence is conditional. That means that at the end of 2 years after the start date on your green card, you have to file for removal of conditions. And the petition for removal of conditions is the I-751. And that's the petition that we're talking about. And that's the denial that I was reading yesterday. It was a very straightforward denial. And it just basically said, you didn't submit enough marital evidence to show that you're still married. Now, this is ridiculous. An I-751 where the marriage is still valid should almost always be approved. If you've been living together for 2 years since you got your green card, you should have 2 years of bank statements. You should have 2 years of evidence living together. You should have 2 years of evidence of trips that you've taken together. So you should have tons and tons of evidence at the end of the 2 years when it comes time to file the I-751. Now, this person filed the I-751 jointly, and that's how most people file the I-751. They file it with their U.S. citizen spouse. That's what happens in the vast majority of cases. Here at our office, we call that a joint I-751, and it's jointly filed, so we call it a joint 751. We also have another way of getting people their conditions removed, and we call that a solo 751. And a solo 751 means that you're filing it without your spouse. And now this person was apparently having problems with their spouse, and they went ahead and filed it jointly. And that's usually a bad idea. You can get the conditions removed on your 751 all by yourself if the marriage was real. And that's the key point. You're going to have to prove that the marriage was real. You're going to have to prove, just like you did when you got the original green card, that now 2 years later, this was a real marriage. But if you have filed for divorce, or if your spouse has filed for divorce, or if your spouse has passed away, and if the divorce is final, you can file without your spouse. And you can just say, this was a good faith marriage that didn't work out. We've handled tons and tons and tons of these cases. Now, you can also file on your own if you've been the victim of violence from the hands of your U.S. citizen spouse. The Violence Against Women Act allows men and women to file an I-751 on their own and to get those conditions removed. The last way that you can file an I-751 solo is if you can show it would produce an extreme hardship if the conditions were not removed. And that could be hardship to you or to a family member. Now, the regulations are not very clear on what constitutes extreme hardship for cases in which someone files an I-751 solo, an I-751 without their spouse. but generally it's going to be the typical kinds of hardship that we usually need to show in other kinds of cases, namely that it would be really, really hard, more hard than for other people to be separated from people in the United States, to have to go back home. You can really put together a lot of evidence of conditions in your home country and demonstrate why it would be an extreme hardship for you to go back. All that being said, those are the ways that you get the conditions removed. When you file an I-751 to get your conditions removed, you immediately receive a letter from USCIS that extends your lawful permanent resident status for 2 years. These cases used to take 2 or 3 months to get approved. Now they take 2 years. So now as soon as you file an I-751, you get that automatic letter extending your status for another 2 years. And that is what this person received. She received that automatic 2-year letter, but eventually she received a request for evidence, a notice of intent to deny. She submitted some more evidence, and the case was denied. Now let's talk about the denial itself. It was pretty harsh. It had a lot of harsh language in there. It said she had to return her green card immediately. It said her status was terminated and that she no longer had status in the United States. And finally, it said that she might be receiving a notice to appear. Now, for those of you who don't know, a notice to appear is the way that the Immigration Service or Immigration and Customs Enforcement start deportation proceedings against you. Now, I have seen denials of I-130s that included a notice to appear, but this I-751 did not include a notice to appear. So the one thing that this person needs to make sure to do is they have to make sure to keep checking the 1-800 number, 1-800-898-7180, to see if their case is in removal. And they would do that by calling that number, punching in their alien number, and then seeing if they have a court date. They would, of course, also check their mail regularly to see if they are in removal proceedings. The next thing they need to do is immediately file a new I-751. Now, I mentioned it a little bit earlier that this particular person is having problems with their original spouse, and so therefore we are going to have her file an I-751 without him. We're going to have her file an I-751 solo, demonstrating we hope that it was a good faith marriage and that the case should still be approved and that her conditions should be removed. Now, USCIS will receipt and will begin processing a second I-751. A lot of people don't know that, and a lot of people just assume or wait to be sent to the immigration court. That is a really bad idea. Instead, what you need to do is immediately file another I-751, a much stronger I-751, and you need to work quickly because you're sort of racing against the clock. There's a very good chance that USCIS might issue you a notice to appear. They might send your case directly to the court, or they might refer your case over to ICE and let them send your case to court. So you really need to work quickly to get this I-751 solo on file. The last thing, of course, is that this is now going to cost her a whole lot more money than it would have if she had hired us from the beginning. I just point that out because a lot of times people think, oh, I'll just take my shot, and then if things don't go well, I'll talk to a lawyer and hire a lawyer at that point. That's a really bad philosophy. That's really the backwards way of doing it, and we don't recommend it. So we're certainly happy to try to help this client. It's a much more of an uphill battle. It's going to be a lot harder to get the case approved, and this is a lesson in how 751s work, in why it might be a good idea to work with an immigration lawyer from the start, and what you can do, what your options are when your I-751 gets denied. We hope you found this helpful. If you did, give us a call, 314-961-8200. You can email us at info@hackinglawpractice.com. Be sure to join us in our Facebook group, which is called Immigrant Home. We have thousands and thousands of immigrants in there who are talking every day about their cases. And of course, don't forget to subscribe to our YouTube channel. That way you'll get updated whenever we make a new video like this one. And you'll also be alerted as to when we're going live on our Immigration Answers live show, which we do 3 or 4 days a week. And we'd love to have you join us for that. Thanks a lot and have a great day.